Thank you so much. Thank you all for being here. Welcome to Panel 2, Students, Teachers, and the Politics of Speech in Schools. My name is Nadine Farid Johnson. I'm the Policy Director for the Knight Institute, and we are really happy to have you here today with this esteemed panel. So in this discussion, we are going to examine a few questions that address issues that are currently playing out in public schools and universities across the country. We'll talk about what limits can a democratically elected government legitimately place on conduct and content in the classroom. When do those limits become illegitimate interferences with the First Amendment rights and values? And whose rights should be prioritized when classroom rules become contentious? The teacher, the student, or the community? So I will first introduce our panelists. Derek Black is a professor of law and the Ernest F. Hollings Chair in Constitutional Law at the University of South Carolina School of Law. He also directs the law school's Constitutional Law Center. His areas of expertise include education law and policy, constitutional law, and civil rights. The focus of his current scholarship is the intersection of constitutional law and public education, particularly as it pertains to educational equality and fairness for disadvantaged students. His research has been published in the Yale Law Journal, Stanford Law Review, NYU Law Review, California Law Review, Cornell Law Review, Northwestern University Law Review, Vanderbilt Law Review, and dozens of others. His work has been cited by federal courts in various briefs before the U.S. Supreme Court. Based on that research, he offers expert witness testimony in school funding, voucher, and federal education policy litigation. He is the author of a leading education law textbook, Education Law, Equality, Fairness, and Reform, and two other books aimed at wider audiences, Schoolhouse Burning, Public Education and the Assault on American Democracy, and Ending Zero Tolerance, The Crisis of Absolute School Discipline. He began his career teaching at Howard University School of Law, where he founded and directed the Education Rights Center. Prior to teaching, he litigated education cases at the Lawyers Committee for Civil Rights under law. Heidi Kitrosser is a William W. Gurley Professor of Law at Northwestern University. She is an expert on the constitutional law of federal government secrecy and on separation of powers and free speech law more broadly. She has written, spoken, and consulted widely on these topics, and her book, Reclaiming Accountability, Transparency, Executive Power, and the U.S. Constitution, was published in 2015 by the University of Chicago Press. It was awarded the 2014 IIT Chicago Kent College of Law Roy C. Palmer Civil Liberties Prize, and her articles have appeared in many venues, including Supreme Court Review, Georgetown Law Journal, UCLA Law Review, Minnesota Law Review, and Constitutional Commentary. In 2017, she was awarded a Guggenheim Fellowship for a book project on U.S. government whistleblowers. Professor Kitrosser is on the steering committee of a new initiative, the Free Expression Legal Network, spearheaded by Yale's Media Freedom and Information Access Clinic and the Reporters Committee for Freedom of the Press. She holds a BA from UCLA and a JD from Yale Law School, where she won the Harlan Fiske Stone Prize for Best Oral Argument in the Morris Tyler Moot Court of Appeals. Following law school, she clerked for Judge William Rhea on the District Court for the Central District of California and for Judge Judith Rogers on the U.S. Court of Appeals for the District of Columbia Circuit, and worked as an associate in the Washington, D.C. office of Jenner and Block. Caroline Mala Corbin is a professor of law at the University of Miami School of Law. She teaches U.S. Constitutional Law 1, U.S. Constitutional Law 2, First Amendment and the Religion Clauses, the Free Speech Clause, Feminism and her First Amendment, and advanced topics in reproductive rights. Her scholarship focuses on the First Amendment's speech and religion clauses, particularly their intersection with equality issues. Her articles have been published in the New York University Law Review, UCLA Law Review, Northwestern University Law Review, Boston University Law Review, and Emory Law Journal, among others. Her writing has also appeared in the online editions of the Harvard Law Review, University of Pennsylvania Law Review, Michigan Law Review, California Law Review, and Virginia Law Review. As well as writing for Take Care blog, ACS blog, and NBC Think, Professor Corbin is a frequent commentator for local and national media on First Amendment questions. She joined the Miami faculty in 2008 after completing a postdoctoral research fellowship at Columbia Law School. Before her fellowship, she litigated civil rights as a pro bono fellow at Sullivan and Cromwell and as an attorney at the ACLU Reproductive Freedom Project. She clerked for the Honorable M. Bain Michael of the U.S. Court of Appeals for the Fourth Circuit. She holds a BA from Harvard and a JD from Columbia. She was a James Kent Scholar at Columbia, where she also won the Pauline Berman Heller Prize and the James A. Elkin Prize for Constitutional Law. And finally, Emerson Sykes is a senior staff attorney with the ACLU Speech, Privacy, and Technology Project, where he focuses on First Amendment free speech protections. From 2019 to 2020, he was also hosted At Liberty, of At Liberty, the ACLU's weekly podcast. Prior to joining the ACLU in 2018, he was a legal advisor for Africa at the International Center for Nonprofit Law. In that role, he provided technical legal assistance to civil society leaders, government officials, law students, and other stakeholders from across Africa to improve the legal framework protecting the freedom of association, assembly, and expression on regional and national levels. From 2012 to 2013, he served as Assistant General Counsel to the New York City Council, where he worked to increase transparency for council members' discretionary spending and contributed to the council's Friend of the Court brief against the NYPD Stop and Frisk program. In 2011, he was a Senior Policy Fellow in the Office of a Member of Parliament in Ghana. He previously conducted research and wrote about U.S. foreign policy for the Century Foundation, a progressive think tank, and worked for the National Democratic Institute Central and West Africa team. He holds a JD from the New York University School of Law, where he was a Root Tilden Kern Scholar for Public Interest Law, and a Master of Public Affairs degree from the Princeton School of Public and International Affairs. He earned his undergraduate degree in political science at Stanford. So we have a great panel, and to get us started, I'm going to provide a few data points, including some released just yesterday. According to a new analysis by the Washington Post, 3 out of 4 school-aged American students are now educated under state-level measures that either expand or sharply limit teaching on issues of race, racism, history, sex, and gender. 2/3 of all state-level policies related to teaching these topics are restrictive in nature, affecting almost half of all school-aged students in the U.S. And this is, to the topic of our panel, greatly influencing how teachers and professors are formulating their curricula. The 2023 State of the American Teacher Survey, a nationally representative study from RAND, released in February of this year, found that 65% of K-12 teachers report they are limiting instruction on political and social issues. So with that bit of background, I'm going to turn to Emerson, and I'll ask you to further set the scene for us here. So you're leading on a number of the key legal challenges in this space. I'd love for you to unpack for us, what are the current controversies and flashpoints as you see them, and what challenges are emerging?
Thank you so much, Nadine. Thanks to the Knight Institute and Katie for organizing. After hearing those bios, I have journal envy, but I guess I'm here to talk about other things than my writing. So at the ACLU, I'm a First Amendment litigator, but I work on a lot of issues that relate to both free speech and racial justice. And as I told one of our paper writers, Heidi, yesterday, I think it's very important where we start this story. So for generations, we had a very whitewashed version of our history taught in schools. That's the version of history that I was taught in school. And is only over the last few decades that we've seen significant progress in terms of having a more inclusive and diverse set of narratives that are actually included in our school curricula. And that's through the hard work of progressive educators across the country. What we've seen, though, more recently, as a First Amendment litigator, we spent 2020 doing protest cases. There was what people were calling a national reckoning around race. People were taking to the streets to voice their discomfort, and they were fed up with continuing the conversation around race in the country as we had been having it, and we were looking for a new way of addressing these issues. That was 2020, when we saw protesters' rights being challenged, and it's no coincidence that we switched from protecting the right to protest around racial justice to very soon after that, I spent all my time working on these backlash efforts, these efforts to restrict how we teach about, learn about, and talk about our history, and the good and the bad and the ugly of our history. So one other piece, I think that there was a direct line between the sort of racial reckoning of 2020 and the backlash that we have seen since in the classrooms. And another piece of it that I think it's important to note, though in my mind it's always very separate, COVID, the pandemic, is a health and education don't necessarily have a lot to do with each other in my head, but for the folks who are behind a lot of these, what people call education gag orders or bans on inclusive education, the distrust around masking, the distrust around the vaccine, was very closely tied from the very beginning to these efforts to root out books that we don't like, ideas that we don't like, to try to have parents controlling not only their own child's education, but controlling what all children have access to in schools. So we saw former President Trump came out with an executive order, 13950, which many folks peg as a seminal moment in this development. The executive order included 8 divisive concepts that were prohibited from government trainings, as well as those conducted by grantees and contractors. Now, the executive order was actually, as many people in this room probably know, was actually enjoined by a federal court, and President Biden withdrew it on his first day in office. So this executive order actually never really went into effect in any meaningful way, but it has been copied and pasted hundreds, if not thousands of times into not only statewide laws, but also school board regulations, resolutions, all sorts of other legal or quasi-legal documents have copied and pasted this same list of divisive concepts. Some of the concepts are pretty innocuous. So the first one says, you're not allowed to teach that one race is morally superior to another. Right? You're not allowed to teach that one race is morally superior to another. Now, no one was actually teaching that, so banning the teaching of that doesn't necessarily seem like such a big deal. There are other provisions, there are other banned concepts that are totally nonsensical. So the fourth one is one of my personal quote-unquote favorites. It says that you're not allowed to teach that anyone, quote, cannot or should not attempt to treat others without respect to race or sex. Again, you're not allowed to teach that anyone cannot or should not attempt to treat others without respect to race or sex. So if you understand that, you are far smarter than me. I've read it hundreds of times and I still don't get it. Our judge in Florida actually said this phrase achieves the rare triple negative. So some of these divisive concepts are innocuous, some of them are nonsensical, but some of them get very to the heart of the progress that we were talking about. There's one that says that you're not allowed to teach that anyone should feel guilt, anguish, discomfort, or any other form of psychological distress on account of race or sex. And there, what they're talking about is discomfort on the part of white children from learning about racism. They were not concerned about the discomfort that people like me felt from not being in the curriculum. There's a very specific kind of discomfort that they're targeting. They also have a provision in many of these laws that says that specifically mentions unconscious bias, or that you're not allowed to teach that anyone should be treated adversely in order to right historic wrongs, getting at the idea of affirmative action. So many of these divisive concepts get directly to the kinds of ideas that actually were being taught and brought into the classroom. We spent a lot of time trying to sort of early rounds of these bans were calling them critical race theory. And we spent a lot of time saying, no, that's not really critical race theory. Critical race theory is something different. These are bans on inclusive education. And in one of our cases, we are representing critical race theorists who in Florida were being prohibited from actually teaching critical race theory. So on the one hand, it's a mislabeling, it's a miscategorization. On the other hand, critical race theory is very much within the crosshairs and it's worth defending on its own terms. So I'll talk just a moment about sort of the trends that we're seeing now. I can talk more about the legal cases that we've brought. But we saw the CRT and divisive concepts bills, and alongside those, what were called Don't Say Gay laws, which similarly targeted what could be taught, how we could talk about ourselves and our society and the variety amongst us in our schools. And the legal challenges, I will say, to both the inclusive education bans and the Don't Say Gay laws have had mixed success. We can talk about there have been some very important victories. There have been some sort of split decisions, and there's been some pretty bad losses as well. But we can talk about those in more detail if folks are interested. We talked about the gag orders. Alongside these, there have also been book bans. I'm sure everyone's quite familiar with this. This is not a new issue. Book bans are an old trick of the despot, but they are coming back. Penn America, I see our colleague Jeremy Young, and Nadine was formerly at Penn as well, are doing a lot to track these trends, track these laws, track these book bans. But suffice to say, it's a huge problem, a linked problem. And I would say the most recent iteration, not that these other two trends have completely passed, but we've also seen a new focus on quote-unquote DEI. It's sort of the new CRT in terms of a catch-all for the things that a certain sector of advocates are trying to push back against. And we're seeing these attacks on DEI come in various forms. In the workplace, as well as in higher education, with regard to curriculum and tenure, but also in K-12 education as well. So as we think about the impact that these measures have had on teachers, but also on students, it's dramatic. These laws are in force in a handful of states, not a lot of states, but they are, as you said, 50% of students are going to a school district where in some way, shape, or form these laws or these policies are in effect. And even beyond what is actually banned by these laws, teachers have no choice but to avoid these topics altogether or risk discipline, right? So my wife is a teacher, my parents are teachers. They're in an impossible position because they are taught in their teacher education how to reach students, how to create an inclusive classroom. Even the state standards in many of these places say you're supposed to create critical thinkers. You're supposed to convey information in a way that is inclusive and that encourages participation by students, while at the same time, the state legislature is saying you're not allowed to talk about race or sex in a way that we don't like, in a politically incorrect way. And so what do? They avoid the topics altogether, and the teachers suffer and the students suffer. So we are trying our best to figure out the best legal arguments we can bring to bear, but suffice to say that the Constitution and the First Amendment will not save us here, as it often will not. But we think that there is an important role to play for strategic litigation, for advocacy, in trying to push back against these trends. And I look forward to hearing from my panelists to their areas of expertise as well.
Great, thank you so much. And we will actually be talking later on about some of the non-First Amendment solutions, as well as what the panelists think about other means of addressing these issues. So Derek, I'd love for you to chime in on the broader context here, because your research has highlighted the undermining of public education more broadly and the corresponding effect on democratic norms. And you have a forthcoming piece as well. I'd love for you to talk a little bit about that for us, where you're situating education as a measure of democratic health or erosion, and exploring the implications for free speech doctrine therein. So I'd love for you to tell us about your work and expound upon whether you see the developments that Emerson laid out as having roots in the same kind of policy challenge, and how might you place the gag orders, the bans that we're seeing in this context?
Yeah, thank you. Thanks Nadine and Katie and all the folks at the Knight Institute for putting this together and inviting me. Yeah, I think I've spent most of the last decade trying to sort of rebuild sort of the idea, or sort of forward the idea of education as a pillar of American democracy, and sort of to understand that the underfunding of public education, the privatization of education, was a threat to democracy itself, not just schools, right? And more of a sort of positive view, like let's put education back on a better pedestal and put it under sounder financial footing. But the last few years, and some of my sort of interactions with international rule of law experts and sort of rule of law issues here at home, sort of triggered my mind that, well, if education is a mechanism through which we build democracy or reinforce democracy, certain attacks on it may also be indicators of democratic erosion. And so what I've really been researching a lot is really trying to think in the international context what role schools play or don't play in the building of democracy. And most of the literature, when you sort of look at rule of law and democracy issues, and democratic erosion being the term now, look at sort of major measures of democratic erosion, or sort of major changes. They look for free and fair elections, they look for independent judiciary, they look for some core individual rights, which of course free speech and free association are part of them, and this sort of general catch-all of faith in institutions, right? And education, for the most part, gets lost in that conversation. But as I began to think about all of the things that Emerson has been litigating and discussing, it seems to me that those go to two core pieces of that process. One are the individual rights, but also the faith in a core institution. And one of those individual rights is also the free press. And when you think about what's happening with schools, it's very analogous to despotic control of the media, right? The control of information, right? Now, in other places that don't have, or sort of burgeoning democracies that maybe have a less robust public education system, right? You don't worry about controlling the school, you want to control the press. And of course, we've seen assaults on the press here, but it seems to me that we can look at the gag orders, the sort of changes to the curriculum, the other things that are happening in schools as being an attempt to control the flow of information, right? And control it to a captive audience. And when thought of that way, it should send up red warning signs, not just to the education scholar, not just to the free speech scholar or litigator. It should send up red warning flags to rule of law and democratic erosion scholars. And so what I'm trying to do right now is sort of situate a lot of these things that we think about as being education specific as being much larger sort of concerns. And you also see, and this was sort of raised in the earlier panel about governors and other sort of imposing issues, you also see a lot more autocratic decision making in public schools now. I had state superintendents who I remind them, although they didn't recognize it, that they are independent constitutional officers. They answer to no one, not the governor, not the legislature. They answer to the voters. That's it, end of case. So once you have 4 years, you're in, no one can get rid of you. But what you saw are any number of governors asserting power over an education system, and I have another paper about this, that they don't actually possess, right? So again, it's not just they're controlling the schools for the control of information, they're doing it in an autocratic way in some instances, which again, another red warning sign for democratic erosion. You can also, and you think about prior restraints, for instance. Well, which, as the earlier panel said, it's supposed to be, absolute no-no. Well, think about the parental rights statutes that have been floated out. What are they other than saying you can't teach anything that mom and dad objects to on that day, right? The bill that was put forward in Indiana gave every parent, fortunately it didn't pass, gave every parent in the state the right to email and question the curriculum that morning before it was taught, right? The teacher's supposed to post it at 8 o'clock in the morning. And first of all, I don't know how you would teach anything if you're responding to parent emails. But in any event, you sort of have that problem, right? Again, another sort of red warning sign of democratic erosion. And so our current constitutional doctrine is, I think, pretty naive about schools, and rightly so. It has this sort of positive view of schools, maybe, that I've tried to champion. Oh, they're the sort of place where democracy happens, we need to defer to them, we need to have debate, and they're all well-meaning, right? And I think in a normal functioning democratic system, that's right, school does deserve a lot of deference, maybe even more deference in terms of how it deals with teachers than some other people might be comfortable with. But I think democracy is not the same in year 1 as it is in year 10 or year 100. And if what we're going through at this particular moment in time is democratic erosion, then some of the rules of thumb, some of the sort of deference that we would normally afford to pedagogical judgment, right, that we would normally afford to government speech, need to be scrutinized, right, more heavily than the current doctrines of Pico or Garcetti or other sort of government speech cases would allow. And so I think, in my mind, what courts need to do is, number one, recognize that we are in a democratic erosion, potentially a democratic erosion scenario in which we need to see what's going on here, no different than a compelled Pledge of Allegiance, in Barnett, and cast a much more skeptical eye on it. But that perspective is sort of the key. Do we perceive this as business as usual, managers doing what managers are supposed to do, or principals doing what they're supposed to do, or are these autocratic takeovers by legislators and other sort of public officials, which really ought to frighten us more than probably these people in this room are probably frightened, but sort of the average citizen is frightened. So.
Yeah, I agree with the sense of palpable fear, I think, in a lot of people in this room. So thank you so much for sharing that and for offering that perspective. I think, I'm going to ask the audience now, remember, there's a QR code here. You can scan at any time to ask questions, and they will pop up on this handy iPad I have in front of me, so we will be happy to take your questions at any point. Later on in the talk, if you prefer to use a mic, we will open up for mic questions. But I'd like to turn now to Heidi and Caroline about government speech. Each of these scholars is working on some really thought-provoking pieces about this issue and how to address this in the classroom. And these bans and these gag orders that we're seeing across the country, they are justified as government speech. So I'm going to ask each of you, and Caroline, I'll start with you. Can you provide for the audience just a quick primer on government speech doctrine, where it is, what it is, where it comes from, and how, in your view, it works in the public education setting? And we'll turn to Heidi, and then I'd like each of you to talk a little bit about your pieces. But I'll start with you, please.
Okay, sure. So I'm going to give you a little primer on, you're probably thinking to yourself, well, this is the government censoring what somebody says. Is this not a paradigmatic free speech violation? Why aren't these school teachers lining up in the courtrooms and suing over this restriction on what they're allowed to say in the classroom? And the reason they cannot is the government speech doctrine and how the government speech doctrine has been incorporated into the rules regulating the kinds of free speech claims that public employees can make. So here's the government speech doctrine. It's actually simple. Very few things are simple in constitutional law, but this is actually one of it. And here's the rule. If the government is speaking, that speech is not protected by the free speech clause. That's it. Right? So if the government is the speaker, it does not trigger any free speech scrutiny, because the free speech clause is supposed to protect private speakers from the government. It doesn't protect the government itself. And so you may think, okay, but what about if the government is saying really awful things, or is censoring everything that someone can say who's a government speaker? And the response in the doctrine, don't get mad at me, I'm just telling you what the doctrine is, right? The response is, if you do not like what the government is saying, then you vote for a different government that's going to say something else. So the answer to how do you solve a problem like bad government speech is you vote. It's democratic accountability. So that's sort of the basics on government speech doctrine. And the government speech doctrine, it's new. It's not brand spanking new. It's newish. Started with Russ Free Sullivan about the gag rule on doctors and their patients trying to find out about abortion. But it's infected a lot of areas, one of which is government employee speech. Now, government employees never had the same range of free speech rights as workers as they did outside the work context. So when you're a government employee, like employees everywhere, your free speech rights are not the same as they are as a citizen. There was some balancing between what you said and the government's interests. But the way the government speech doctrine has come into government employee speech is that if you are a government employee, teachers here, public employees, this applies to public school teachers, not private school teachers. The rule is, if what you say is pursuant to your official duties, that is, if you are speaking, fulfilling your job responsibilities, what you're saying is part and parcel of what you are paid to do, like teaching a class, then it's considered government speech. And what do we know about government speech? Not protected by the free speech clause. All right, so the first question is, why aren't these teachers suing? They can't, right? Or it's a non-starter if it's about their classroom instruction. Now, if it's beyond that, there's a slightly different doctrine. But the basic idea is teachers cannot challenge limits on what they are teaching in the classroom People are mad about this. Right? That's wrong. And yet,
Yes.
right? Because it's considered government speech, they can't. So
Thank you.
I
So-
do the blunt stuff. I'll let Heidi do the nuance.
So, as you see from your phones, aftershocks may occur. Please stay rooted to your seats, listening to our panelists. All right, great. Thank you, Caroline. Heidi, can you talk a little bit about this in terms of your perspective, please?
Yeah, no, absolutely. So Carolyn, of course, is absolutely right in terms of the state of the government speech doctrine. What I have observed, though, and what I talk about in the paper that I wrote for this symposium, is I find little tiny glimmers of hope in other aspects of the free speech case law, because government speech doctrine, again, is exactly as Carolyn described it. That said, I think it is in tension with some threads that you can find in other aspects of the free speech case law. And in these other threads, I think you can sort of pull them together and identify a principle that I refer to as the anti-distortion principle. And that is the idea that, yes, if something is characterized as government speech ever since Rust v. Sullivan, and a court agrees this is just the government speaking in the way that Carolyn described, they can do whatever they want. At the same time, there is this other sort of principle, again, that you can find in numerous spots in the case law that say, when government creates some kind of institution or subsidizes some kind of institution, and that institution engages in speech or disseminates communications which purport to sort of follow, let's say, disciplinary norms. So say, for example, and here I'm drawing from a real case called Legal Services versus Velasquez from 2001. So say, for example, that the government funds the Legal Services Corporation, that they subsidize that. And they say that as part of this, what we'll be doing is paying lawyers. And when you fund lawyering, you sort of get a lot of baggage with that, not only in the sense that lawyers, we're all difficult people, but also in the sense that, you know, lawyering comes with certain professional norms, ethical norms, and requirements and expectations. And so, that being the case, the government in the late 90s placed some conditions on funding legal services attorneys. They said, well, there are certain kinds of arguments that legal services attorneys can't make. They can, if they're representing a client and let's say they're contesting some sort of benefit denial or problem with benefits, it's fine if you want to argue to a court that the person the person handling the benefits, a particular worker, that they misread the statute, they misapplied it, and so they made a mistake. But you can't make arguments that would call into question the legality of the actual statute or regulation that that worker was implying. So you can't, for example, argue that a particular statute that affects your client is unconstitutional. And in this case that I mentioned, Legal Services versus Velasquez, the court said, well, actually you can't do that. That's effectively an unconstitutional condition because yes, it's true that the government sort of funded and created this legal services program, but once they did that, they've kind of tied themselves to the mast of the norms and expectations, the public expectations, ethical requirements that come with lawyering. And what they've done in imposing this requirement is they've purported to fund lawyers, but then they've distorted the system of lawyering that they created by imposing this sort of impossible condition on the funded lawyers saying, go be a lawyer, but don't advocate zealously for your client in the way that lawyers are expected and ethically required to do. Don't make every plausible argument basically if it could make the government look bad if you're challenging the constitutionality of a statute. So that's an example of what I refer to as sort of the anti-distortion principle in action. We see it elsewhere in the case law. For example, the government is not required to create forums for people to speak. And when they do create forums, they can impose a lot of limits. They might say, we're just creating, for example, a public band shell. And we're not creating Hyde Park here. We're not creating a place where anyone can go and say anything they want. We're creating a band shell for a particular purpose, to do performances, and there are reasonable regulations in terms of signing up for particular times, et cetera. Even then, though, the court has a longstanding rule saying, but one thing government cannot do when they purport to create that kind of forum is impose requirements that are inconsistent with sort of the purpose or the nature of the forum. So in this and in some other cases, I identify this so-called anti-distortion rule, right? The idea that government, when they employ someone or create an institution or fund a certain type of speech, they do sort of tie themselves to the mast of the norms of the discipline or of the speech institution. And I think that provides a little bit of a glimmer of hope, because it is in some tension with the government speech doctrine and provides, I think, a potential limiting principle. And indeed, Carolyn mentioned the Garcetti case. Garcetti itself arguably has the seeds not only of an anti-distortion principle, but one that's actually specific to education, albeit in the way the court described it, possibly just to higher education. And that is, in Garcetti, one of the dissenting justices said, this Garcetti rule is terrible, it's very problematic, and one of the things that it could do is threaten academic freedom, because a lot of public employees are teachers. And a lot of them are teachers in K through 12, but a lot of them teach in higher education or college faculty. And the whole point of being a faculty member and doing research and teaching is to cultivate knowledge, to do research, to take the research where the direction in which it takes you, to cultivate critical thinking in the classroom, which is really antithetical to the government effectively being able to dictate to you what you can and cannot say. The majority in Garcetti actually suggested, although they didn't decide anything because it wasn't directly relevant in that case, but the majority actually said, you may have a point. There may be some separate academic freedom considerations in that type of case. We won't deal with them here. So that's a glimmer of hope for academic freedom, but I also argue that although the court didn't articulate this, I think there's a way you could make sense of it that also ties to a broader anti-distortion principle, that perhaps the reason there might be an academic freedom limitation on Garcetti and on government speech doctrine more broadly is because without it, you would allow the government, by imposing restrictions on what teachers can say in public institutions, to effectively be creating an institution and then sort of distorting its nature. So essentially what I argue about in the paper for the symposium is a way of kind of deepening the anti-distortion principle, which, as I note and as I've suggested in a couple of examples, is really just hinted at in the cases right now. And I think there are two ways, and I'm happy to elaborate on it if people want to hear more about it, but I'll just to kind of tie this up. I think there are sort of two ways in which the principle is really not at all fleshed out in the cases and in which it really needs to be built on, which I try to do in this paper. Right now it's just a draft. I'll try to do it even harder between now and writing the final piece. But one way is we need more justification. The court sort of hints at this idea of distortion being a problem, but doesn't really explain why. It raises free speech alarm bells. And then the second is, well, how do you determine what the very nature of an institution is, right? What's the baseline so that you know whether it's being distorted or not? And so those are probably the main things I try to tackle in the paper. And in particular, I apply them to a few examples of the type of litigation that Emerson was talking about.
Great, thank you so much. And at some point, I hope we can come back to your the discussion of the normative aspects, particularly with respect to the public school setting. I know you talk about PICO, which has been raised elsewhere as well. But Caroline, I want to actually come back to you because Heidi mentioned Garcetti, and you've written about the problems with Garcetti from your perspective, particularly with respect to audience rights. So if you can talk to us about your piece and your proposal here, and tie it into, we'd love to hear about how you view audiences and students and how those rights are the same or not the same.
So yeah, so the starting place for my piece was about, again, the regulation of teachers in the classroom, in particular with regard to LGBTQ issues and students. And so there are sort of two clusters of regulations that have arisen recently. One, as you heard, are the Don't Say Gay laws, which basically forbid teachers from instructing on sexual orientation or gender identity. And Florida was a pioneer. I live in Florida. I have an endless supply of things to write about living in Florida. So anyway, Florida pioneered those laws, and there are several other states who have passed them. At the same time, in other states, whether because they are concerned about classroom equity and inclusion, or whether they're worried about Title IX and possibly violating it, have mandated that their teachers and coaches and personnel use appropriate pronouns and names. In other words, with regard to their transgender students, these teachers are required to use the names and pronouns that match the gender identity of their students. And teachers are mad about both sets of laws, right? On the one hand, you have teachers who do not want to have entire topics excised from their classroom. On the other hand, you have a lot of devout Christians, because they're always Christian, who fervently believe that God has made only two sexes and that the sex is set at the moment of conception, and therefore using appropriate pronouns is forcing them to speak against the truth. And so again, both of them seemingly have First Amendment claims, because censoring your speech or compelling you to speak, both of these are protected by the Free Speech Clause. But for the reasons I mentioned earlier, as teachers, they can't bring free speech challenges to their classroom instruction and what they say during the course of pursuing their official duties. And so, that's the background. Now, the crux of my paper is really a critique of the government speech doctrine. Because again, it says if the government is the speaker, then there's no role for the Free Speech Clause, because the Free Speech Clause protects private citizens, not the government. And I think this is a very truncated view of exactly what the Free Speech Clause is meant to protect, because it has never only protected speakers, it has also always protected audiences as well. So if you think about the three major theories undergirding why the Constitution protects free speech, absolutely one of them is about the speaker, right? Free speech promotes the speaker's autonomy, their right to express themselves, their self-realization. That one is more speaker-focused. But the other two are actually more audience-focused. And the other two include creating a marketplace of ideas. You've heard of that one, I hope, right? And what's the point? We want to have a free flow of information, so we have a widely available, perhaps even a cacophony of viewpoints and opinions and information for audiences, right? The marketplace is to ensure that information and opinions is available for the listeners. And the other major reason why we generally understand the Free Speech Clause to protect speech is it's essential for our democratic form of government, right? Voters must have a free flow of information because as audiences, they need to know whether their elected officials are implementing their preferred political policies, right? They need to hear that information. And they need to have a free flow of information in order to develop their preferred policies to begin with. So two of the main theories of free speech are really more focused on a free flow of information so that audiences have access to it. And the government speech doctrine completely ignores that. It looks only at speaker and speaker rights. And it seems to indicate if the speaker is the government, there's no role for the free speech clause. But the speaker is only one end of the stream of speech. Because on the other end are private audiences. And therefore, it is a mistake, basically the government speech doctrine, it is a mistake to say if the government is speaking, there's no role for the free speech clause. And so if we were to take audiences into account when we think about these restrictions on teachers' speech in the classroom, we get a very different kind of outcome than we do now. And so if we're thinking about eliminating discussions of sexual orientation and gender identity from the classroom, and we're thinking about how that affects the students and their free speech rights, you could really make an argument that it undermines them. On the other hand, if you're thinking about students and the targets of deliberate misgendering, you could see how allowing teachers to do that might undermine their rights as audience, because there's a lot of, and I'm giving a truncated version, I'll be happy to elaborate more on these two if you're all interested. I don't want to talk too long. But my point is, if we had a doctrine that remembered that free speech is about a free flow of information for audiences and had a very audience-centered free speech analysis of these restrictions, we might come, or we would come, to very different conclusions than we do now.
Yeah, of course.
So I introduced myself as a First Amendment litigator, and I see Jamil Jaffer. I hope you won't mind me saying this. There are other amendments than the First Amendment. So the panel has done a great job of pointing out all the reasons that it's very hard to bring First Amendment claims on behalf of K-12 teachers, right? I feel like we understand that now. The next panel is about higher education, where different rules apply, right? We argue, and it's better supported in the case law, that college professors do have a First Amendment right over what they teach. Not uncontroversial, but more protections, more recognition in the case law. In K-12, given the fact, why is there this distinction? In K-12, the idea is the students are required to be there. The state controls the curriculum. They create the curriculum. And so it's a different kind of enterprise. And as I said, my wife is a K-12 teacher. I know there's a lot of creativity that goes into it. It's not in any way taking away from the brilliance of K-12 teachers. But there is some logic to the idea that what they're doing is a different job on behalf of, even if it's a government job, it's a different job than the college professor's job. So, hoping that the proposals that my colleagues have proposed eventually are adopted, what do we do in the meantime? There are workarounds, right? So in our cases, we've brought First Amendment claims on behalf of college professors. We've also, exactly addressing this audience issue, brought First Amendment right to receive information claims on behalf of students. That's not super well recognized in the law, but there's a handful of cases that say, as Professor Corbin was saying, audience matters. You have a right to receive information, and students in K-12 have a right to receive information as long as the restrictions are reasonably related to a legitimate pedagogical purpose. So it's a relatively low bar, but there is some hook that we can get with student First Amendment rights. The other big one is vagueness. It's a due process right. So people often talk about overbreadth and vagueness as if they're the same thing, but this is my little hobby horse. Overbreadth is a First Amendment doctrine. Vagueness is a due process doctrine. They're different parts of the Constitution. And even though, it's important because even though K-12 teachers don't have a First Amendment right, they still have a due process right. So that means that you cannot fire a K-12 teacher for violating a vague law. And as I mentioned, we think these laws are quite vague. So we are likely, knocking on wood, to win one or at least two of our federal lawsuits on this vagueness ground, on the idea that K-12 teachers cannot be punished for violating a rule that they can't understand. So it's not to in any way disagree with or undercut the problems with the government speech doctrine and the ways in which K-12 teachers are limited in their ability to vindicate their free speech rights. It's just to say that there are other parts of the Constitution and there are other ways that we can try to attack these things.
That's great. And actually I have a few great questions from the audience that follow along both of these threads here. So, Caroline, in terms of your work and your discussion, you talked about the rights of students, talked about the rights of the audience. What about the claim of parental rights with some of these bills? And what happens when all of these rights come into tension in terms of government speech, for example, in terms of the rights of students to receive information, and in terms of the claim of parental rights?
Parental rights. The right that didn't exist until conservatives wanted to control the public school curriculum. And I say this because so back up a little bit. The substantive due process clause, the same clause that used to protect abortion, also protects the right of parents to control the upbringing of their children. This has been long established. Although often praised, it has heretofore been rarely enforced and definitely not in schools. So the right of parents to control the upbringing of their children comes into play with termination of parental rights, for example. It comes into play with schools in that parents are not required to send their children to public schools, and they have the right to send them to private schools, religious schools, or to homeschool them. But traditionally, well, not anymore. But traditionally, the right of parents vis-a-vis schools ended when they made the decision to send their children to public schools. And once they were in public school, they did not have the right to control what went on inside that school, and certainly not to the extent of denying to other children information, academic subjects. And so occasionally you might have a school saying, okay, you have the right to pull your child out of sex ed, although I think that was more out of a courtesy than any right of parents to control the upbringing of their children. So let me give you a concrete case of how little rights parents have in school. There is this oldish Supreme Court case, I don't remember exactly, but the teachers have a right to beat children in school. And there was a parent who's like, yeah, I don't believe in corporal punishment, so I do not give you permission to beat my child in school. And if you were to think if ever a parent were to have any control of what goes on in public schools, it would be deciding whether or not the school can beat their child, and yet their claim was rejected. Which is why I say historically, there were not parental rights to control what happens inside the classroom gates, inside the school gates. And so to the extent that this has arisen and to the extent it has started to be recognized, I don't know, it's not how we have understood the right at this point. Now, of course, rights will change. We have courts determined to get the outcome they want. I don't know how to respond to that, but generally speaking, as a matter of constitutional law, parents' right with schools ended once they decided to send their child to public school.
Can I just jump in for
one
second?
course.
So one thing I just wanted to add to that is we have seen, there is a really interesting parallel, I think, between kind of the political valence of the parental rights language and the legal analysis by courts in kind of formulating and explaining government speech doctrine. So a lot of the parental rights talk does couch things like, the divisive concepts legislation that Emerson was describing and that's swept the nation. It couches it in liberty and freedom. And sort of the logic of this, such as it is twofold. Partly, proponents of the laws argue, well, children are being indoctrinated in schools, and so what these laws do is try to free them, right? Which is a claim that some, including a district court judge in Florida, effectively described as Orwellian. But the other way in which they couch these laws as actually being blows for freedom is that they say what they do is vindicate parental rights. And so that, that certainly has political, that's certainly a logic that is part of the political discourse behind a lot of these laws, but it also kind of matches up with some of the judicial language and reasoning in some of the major government speech cases. Because one of the, I think, key ways in which the Supreme Court in particular has justified government speech doctrine is they tie it to political accountability. And they say, well, it might seem alarming to people that, government can kind of top-down control all of the bureaucrats, everyone from agency workers to school teachers to even people who work in higher ed. That might seem alarming. That might even seem contrary to liberty. But no worries, because ultimately people can respond at the ballot box. Now that's very problematic in ways that Dan elaborated on at length in the prior panel, in terms of sort of the insufficiency of the ballot box as an answer to this level of control. It's also problematic, I would argue, in the sense that it sort of allows suppression of exactly the kind of information and critical thinking that might make our ability to participate at the ballot box meaningful. And I think that's an argument that's very much present when it comes to allowing sort of legislative and gubernatorial control of what children can be taught, particularly to the extent that the control is taught, or the control is directed toward sort of suppressing critical thinking, keeping kids from perhaps questioning what the government's up to. So, somewhat ironically, I think that kind of control can actually do the very opposite of what proponents of the government speech doctrine claim, which is to further government accountability. And then there's also, of course, the aspect, as I think some of Caroline's comments were getting at, of the effort by parents to exert, parental control to vindicate parental rights as being an effort not just to protect their own children, of course, but to shield or direct what, kids all throughout the school system can learn.
I just thought of a really good example of how pretextual this claim about parental rights and how it's being used to accomplish certain political objectives. So in Florida, there is a law. So there's a very famous Supreme Court case that says you cannot force students to say the Pledge of Allegiance. It's a violation of their free speech rights. Florida has now a law on the books that has been upheld on the ground of parental rights that actually schools can force students to say the Pledge of Allegiance unless their parents give them permission to opt out. And this is supported on the ground of parental rights. But notice how the parental rights work, right? Because if you want to force your child to say the Pledge of Allegiance, that parental right is protected. But if you want to force your child to sit down, that you cannot do. So this is not really about parental rights, is my point. It's just being used to reach certain political objectives.
So thank you both. We have a number of great questions here. I'm going to combine a couple of them and look to Derek first and Emerson, because the questions here are looking first about the fact that are there other ways to fight back, right? What other ways, and what other ways do you see? And then in terms of K-12, Emerson, if you could speak to why we don't have a lot of litigation focused on these areas and what kind of limitations that a litigator would see. But Derek, I'm going to start with you in terms of other ways to fight back. And do you think an approach that is centered on public education as a right Could that be plausible?
Plausible, but work to be done. There are all 50 state constitutions have an education clause that obligates the states to provide public education. It's a constitutional duty, which really provides a sort of huge context for all of this conversation. But putting that aside, and the reason why those exist, and it's in the legislative history, it's in the judicial opinions, is to prepare students for citizenship. That's the sort of shortest way of saying it. All that litigation has almost exclusively focused on school funding and sort of basic educational quality. But theoretically, and I agree that the state does have the right to, or has the duty to prepare students for citizenship. And so certain restrictions of this nature are in direct tension with that. Mike Rebell, who's at Teachers College and Columbia Law School as well, has been sort of litigating around this sort of general citizenship issue. He brought a lawsuit in Rhode Island around citizenship education, and he's thinking about some other state-based litigation right now. I think the new hurdle to sort of move forward to is that prior litigation around the right to education has been very high-level structural litigation, very high-level funding, very high-level education state standards, and to call upon courts to get to what is classroom level instruction, I think asks them to go further than they've had before, but there's no logical reason why they couldn't and shouldn't. It's just we haven't gone there. And also the nature of school funding litigation, which I assume no one in this, well, maybe Emerson is familiar. I mean, it is just behemoth, multi-decade type litigation, and this is more of a needle in the haystack in some respects. So you sort of have to transform that behemoth into something much more narrow, but it is certainly theoretically possible.
The question, why aren't there more cases, it feels like an unfair one for a litigator. My immediate answer is because I got to spend some time with my kids. I'm doing the best I can.
I mean,
But, I mean, it is a valid question, and I think it gets to what I hinted at earlier, which is, what are the rules that apply, right? So if you see, whether it's at the school level or at the district level or at the state level, a change to the school curriculum, right? Something is removed, and you want to challenge it. How do you do so, and why is it difficult? The Supreme Court case that arguably probably applies is called Hazelwood v. Kuhlmeyer, which is from a very different context. It's a school newspaper case, actually. I know Frank used to be at SPLC, so it's a classic student press case. But it was about whether or not a school could exercise editorial control over student work in a newspaper. And what the Supreme Court said was that this newspaper was an official publication of the school. It bore the imprimatur of the school. Therefore, those who are reading it might reasonably interpret it as having been approved of by the school, even though it's under the byline of a particular student. Clearly, we understand this is a school publication. There's a faculty advisor. This is, in some sense, school speech. It's not quite government speech in the way that we're talking about it today, but it is in some sense speech that has been endorsed by the school. And if the courts are going to second guess that editorial control that's exerted by the school, they can only overrule the school when they find that the school's action was not, quote, reasonably related to a legitimate pedagogical interest, right? So we're not talking about strict scrutiny. We're not talking about intermediate scrutiny. We're talking about if there's any reasonable relationship to some legitimate pedagogical concern, then the courts are not going to overrule the educator's decision. So what we've done is tried to point out that in these situations, when you have a law that doesn't make sense, that runs contrary to all of the education research, it runs contrary to the statewide standards for how teachers are supposed to act, that in that type of situation, an education gag order, a ban on inclusive education, actually fails this very low bar. Because it is a suppression of speech that is not reasonably related to any legitimate pedagogical concern. The interest here is to score political points. If you look at the quotes from the legislature when they were passing these laws, they were trying to push back against BLM. They were trying to, root out anti-racism and calling it racism. It was not a pedagogical concern, and to the extent that they stated some legitimate pedagogical concerns, that is, improving students' understanding, preventing harassment and discrimination, those are pretextual, but assuming that those were the legitimate pedagogical concerns, the policies that they've implemented are in no way in furtherance of those goals, right? Saying that you're not allowed to teach about implicit bias or unconscious bias does not further any legitimate pedagogical concern. So the reason that it's hard to litigate in this area is because courts are, I would say, even understandably deferential to education officials. We wish they were deferential to education officials in other ways. But here they're saying that a judge should not be second-guessing the choices of a school unless what they've done is obviously wrong, to put it in layman's terms. So the bar is quite low, and so that's why it's hard to litigate in this area, unless you have these really egregious examples, which we argue we do have here.
Can I just quickly, and I think that it really sort of hits on the problem. It's like, what's the limiting principle? I mean, I think, as Emerson's suggesting, right, that schools do need to be able to go about their everyday business of sort of reasonable pedagogical judgments, but at some point they cross the line. And I think the difficulty, and we sort of, I don't want to throw out too many constitutional sort of ideas here, but sort of go to equal protection where we have this sort of rational basis with a bite when we get this sense, such in Romer versus Evans, which was some anti-LGBTQ legislation and other cases, that there have to be this sort of category of cases that require a little bit more scrutiny than that deference. And that's sort of what has sort of triggered my idea. Say, like, yeah, the average case, deference, but what we have is sort of what looks like authoritarian action or what looks like democratic erosion. Courts ought not be so deferential, because what you're really doing is deferring to authoritarian action, which is not what the Constitution is designed to do.
Sorry, just to tack on quickly, that's especially true. We argue that there should be this sort of extra kickback when it's the legislature that is limiting the speech, right? Whatever deference we accord to teachers, principals, even school boards, shudder to think, in some situations, whatever deference they deserve, the legislature deserves none of that in terms of its expertise and closeness to these issue areas. So we would argue that even under rational basis, it's got to be a little bit plus when you're talking about a non-education official. And just to note, we do also bring equal protection claims as well in most, if not all, of these cases.
Oh, that was going to be one of my questions too. Great. I see this gentleman here, please.
Yes. I'm Michael Myers. I'm president of the New York Civil Rights Coalition. Again. This sounds Byzantine. I don't know how in the world a good teacher, effective teacher, can't get around these Byzantine rules. And surely, when I was a student, we had great teachers who knew how to get around quote-unquote laws that prohibited them, not just through their union protection, but through the Socratic teaching method, having students ask questions, having students read things they are not used to reading, role play in the classroom, not just expressing your point of view, but expressing the point of view of someone who disagrees with you, and taking the role of somebody who disagrees with you. So my question is, in a world where we have required reading, why aren't the teachers requiring people, students, for example, to read the book, The Development of Segregationist Thought? That book was only about segregation, the whole reason, the ideology of segregation. And you're telling me teachers still can't do that under the so-called rules now and the law? Of course they can. So what we have to have teachers who are creative, teachers who are liberating, teachers who will not bow down and kowtow to silly rules.
So that would, of course, right? But the risk is they lose their jobs. I mean, that's the reality, is that their livelihood is on the line. Because, and if you view teaching as your calling, it's your very being. Because again, one of the problems with vague laws, yes, it's a due process problem, but it's also well recognized that when you're dealing with speech, it's also a free speech challenge. Because when people aren't sure about what's going to get them in trouble or not, you know that they tend to err on the side of caution. And so that's why they're not only going to make sure they stay within what's allowed by the law, whatever that is, but they're going to stay way clear of that. And the stakes are high, and the risk is high too, because a lot of these laws allow parents to bring claims. So it's not just that there's so much that's on the line, but it's so easy to lose. Because now you can have parents bring claims, and when you have mad parents, they're not shy about it. You know, a woman showed a Disney movie that had a gay character in it, and she was investigated for that, right? She didn't teach anything. She showed a movie with a single gay character, and her job was on the line. So in that kind of atmosphere, of course you want teachers to say, F it, I'm going to do what I need to do. But you also have teachers who are like, I can't do what I need to do if I'm not even in the classroom.
Well, I would just add some teachers have done that. And I guess it sort of goes back to my concern about democratic erosion. I think under normal circumstances, I think your logic holds. And we're not under normal circumstances right now. This isn't just the principal. It isn't just the governor. It isn't just Florida. It isn't just Texas. It really is an entire, well, maybe some states are exempted, but it is effectively a national form of democratic erosion. And, you know, the level of bravery, I think, that it takes to stand, certainly some teachers have that, but I don't think we can expect the extraordinary from the ordinary.
I would add, though, I think that your description of good teaching in many ways kind of gets at the baseline idea of what what teaching is, essentially, that I think it, in many ways kind of lies at the heart of, even though the kind of legal explanation of what, for example, an anti-distortion might sound, very sort of abstract and purely academic. But in many ways, what you described about teaching is sort of the heart of an anti-distortion argument, a potential anti-distortion argument for K through 12 teaching, which is, to put it in the simplest possible terms, that if teaching K through 12 students, and it depends on exactly what age, what form this would take, but if it's fundamentally, as Derek was also saying, about preparing them for citizenship and preparing them to think critically, there's something very antithetical, obviously, about saying that, well, you can't teach them what the consensus of historians are as to accurate history, or you can't accurately describe to them current debates. And I sort of described how there are little threads you can grab onto in the case law for an anti-distortion principle, and I think what you described about good teaching is kind of where the rubber meets the road in terms of how these laws distort teaching. I think also, you can find a lot of Supreme Court case law speaking in sweeping terms, and this is always dicta, right? And it's not clear that they really mean what they say, but you can certainly find evidence throughout Supreme Court case law in sweeping terms about the importance of teaching to prepare us to think critically, to prepare us to be citizens, that I think also sort of give meat to that argument. And finally, I would say this also ties to Emerson's really important point about Hazelwood, the legitimate pedagogical objective standard, which, even though when Hazelwood came out, everyone said, oh, that standard's nothing, right? It's so easy to pass. But actually, we're living in a world now where laws are being passed that I think there's an excellent argument they can't even meet the Hazelwood standard, which, by the way, is precisely why, and Emerson would know this better than anyone from litigating all of these cases, but that's precisely why, if you look at the government's briefs in some of these cases defending these laws, they're now arguing they don't want Hazelwood. As easy a standard as that is, they say, we don't want Hazelwood to apply. This is government speech, getting back to Carolyn's point, right? We can say whatever we want. Don't even ask if there's a legitimate pedagogical objective. And they've even gone so far, in the Florida case, I saw this in the government's brief, they've even gone so far as to say, even if you apply the legitimate pedagogical judgment standard, that's met intrinsically by the legislature's judgment that these laws are necessary. necessary because it's all government speech. So it doesn't make a difference if it's the teacher deciding, the principal deciding, or the legislature. For government speech purposes, the legislature is the same as a teacher, and you have to defer to their judgment.
It's exactly 12:30. Very well done. That was perfect. Thank you all so much. Really appreciate it. Great panel.